How was the decision taken to prosecute Joshlin's case?
So there is no dedicated capacity or prosecutors specifically assigned to only dealing with trafficking in persons matters exclusively. But we ensure that it's only trained prosecutors that actually do prosecute these matters. So in the Western Cape, I am the NPA nodal point for trafficking in persons in the province. That means I have a coordination role. All matters TIP-related are reported to me. I then guide the investigation in those matters and mostly make the decisions also, and then would allocate the cases to specific prosecutors, trained prosecutors in the different courts. But I coordinate that, and it's very important to remember that in TIP matters, you need a multidisciplinary approach. There's no way that one person or even just one institution or organization, only the NPA or only the police, can ever succeed in properly investigating and prosecuting a case of trafficking in persons.
What goes into the preparation for a case like this from a legal, mental, and emotional point of view?
Legally, the preparation is immense. When I say we've had between us about 10 lever arch files of documents for this case, of evidence, and then you have to sift through that mountain of evidence, some concrete, some substantial, a section 204 in the mix, and then you have to decide and assess its admissibility, the credibility, and how to present it in court. Strategically, you have to anticipate every angle the defense may take, whether it's in fact or in law, and you have to meet that. I know that there were sessions in the afternoon after the case where we would sit down and go, and what about that? Oh, what do we do this? And let's look at the instructions on that. So it was not just preparation before trial, but during the course of the trial that we also had to do this. Mentally and personally, obviously it's a different weight that gets attached. You're working on a missing child case, and that investigation is still active and very much alive. And the fact that we don't have closure, the fact that we haven't found the child is obviously something that weighs heavily on us as mothers, as we both are.
You've described this case as an important one for jurisprudence in South Africa. What does this mean?
This would be the very first time that we actually prosecuted for trafficking in persons where a child was sold and had not yet been recovered. There were 3 other unreported decisions, 2 in the High Court in Gauteng, Pretoria, and 1 in the Regional Court in Pietermaritzburg in KwaZulu-Natal. But in all 3 of those cases, the children were advertised to be sold, and it was reported to the police. So the police could then do an undercover or trap operation. And it was followed. The minute that the child was sold to the police agent, the police immediately arrested the suspects, and the children were all unscathed and unharmed in those circumstances. Here, little Joshlin is still missing. So there was no agreement in this office on the reasonable prospects of a successful prosecution, because this is a challenge, it's something new. We had very limited evidence. Believe it or not, it was a big chance to take. But fortunately, our DPP, Advocate Bowell, supported me, and the decision was taken that we can prosecute the matter and prosecute it in the High Court.
Back in the day, we would be the ones that would have to consult with the witnesses and prep them. With the court preparation officer's involvement in our case specifically, we didn't have to do that. We could sit back and concentrate on the evidence and what the witnesses were bringing to us, because this case is not possible with just the police and the prosecution. It's those witnesses that came to the fore, that testified in our case. And it's not easy for that witness to stand there and be scrutinized and criticized and cross-examined when we are used to it. We stand up every day in court and we're used to the challenge. But when you have people that come from the public, that's your community, that are coming to testify, to convince them to actually take the stand and know that the media that they're being watched by the media, social media, that there's a public, to accommodate the public, which was in numbers on certain days, But for those people to come through, the importance of the CPOs in this process cannot be understated.
When can we expect the matter of the Section 204 witness to be concluded?
Usually, the inquiry in terms of Section 204 and whether the court grants indemnity or not is done part of the judgment, the main judgment in the matter. That's why you would have seen that I've included that in the heads of argument on the merits of the matter. But in this instance, the Honourable Judge decided to defer it and rather deal with it separately. So in this instance, yes, we will definitely be there. The defence counsel will be there. The accused will not be there because they do not play a part in this inquiry. But we will be called on to argue and indicate why we say that she should or should not be granted indemnity. Of course, our argument is that she should be granted indemnity.
We understand that applications for leave to appeal can be expected. What happens next?
The prosecution's role is to respond by defending the conviction and sentence, and we firmly believe it is grounded in both law and fact and supported by the record and the evidence. We do prepare written and oral submissions opposing the appeal, and we will be arguing very strongly that there was no faults or misdirection by the judge in this matter. It's our responsibility, of course, it's not to win at all costs. We are officers of the court and it's our duty to uphold justice. If there has been no error in fact or in law, we will strongly defend the outcome. That is our judgment and sentence. Of course, if the appeal is granted, then we are also part of the process thereafter in whether it is. The process works as follows. If an appeal is dismissed by this honourable court, the defence may then petition the SCA. The SCA can either dismiss it or they can refer it to a full bench of this division. Whichever way it goes, the state will be defending this judgment and sentence at every level.